the very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court to people versus Marquesi Hankey.
And then we have Your Honor.
Good afternoon, Attorney Kevin Hassan, except all right, it's your motion. Caretaker for, so at the very least, the restriction is phone records to contact that.
All right, well, before I hear from the people, counsel, let me just say, you came in here the first time, and, well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought
he cut the tether off, we haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that.
This starts off like a routine motion hearing, but watch closely. The moment the judge asks about that tether, everything flips. In legal terms, cutting off a court-ordered GPS monitor is a huge violation. Question for you. If someone ignores a direct court order this early, should they even be given another chance?
And I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free, your mom gets revoked, you get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because it just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked to different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked to different pins. And one of these calls is recently Monday. There were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up with nobody says about."
Here's the turning point. Judges do give second chances, but only when there's compliance. What we're seeing is a pattern. Violate bond, ignore orders, and then ask for leniency. Legally, that destroys credibility. Be honest, if you were the judge, would you risk public safety here or shut it down immediately?
None of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing. And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kid say, mess around and find out. I guess that's not the quote, but it's close, but I did pretty good. I said it okay. Right now? All right.
So just, if I may, just briefly, my client would like to support.
Go ahead.
I don't think I'm being bad at all. It's very I can't say I'm not here for nothing. So I obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here. I really don't. Truly. So,
That right there, that's not just attitude, that's a warning. The judge is signaling consequences are about to get real. And legally speaking, repeated violations, defiance, zero chance of bond relief. Final question. Is this confidence or a complete misunderstanding of how serious the situation is?
yeah, please so much. Please. So much.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also from my team, the PCC.
Yes, sir. Is all discovery complete?
And I know that's very possible, but it's very possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 9 a.m. in person before Judge Perry. That's right. Court does call the case of the People versus James Whitney.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with an obligation. James Whitney.
This is People's emergency motion to modify bond in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor. They don't call her to show up. She reached out to a friend of my client
Call her to show, to do what?
today to say, I'm afraid. I mean, I would say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock, with 24 hours notice, I could have got a hearing.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not. Because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court can stand in recess.
All right. If you see it. Purple County, Washington, session, the Honorable Judge J. Sedgwick.
You may be seated. Court recalls the case of the People versus Whitney.
Assistant Prosecuting Attorney wants to so much people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newton County. You see to my right. You can see your name before the police. James Whitney.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn.
Sure.
the case, the very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it, because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow.